我哋
It's the appointed time and we have a quorum. I call to order the meeting. First of all, I'd like to welcome the representatives of the administration for joining us. Now, at the last meeting, we were on part 4A of the comparison table, or clause 22 of part 3, division 4. Deputy Secretary, please take us through. We already explained that. We already briefed you on the clause. Oh, okay, yes. So, number of questions, number of members to ask questions. Mr. Jeffrey Lam, thank you. 4A, seditious intention. Personally, I don't see a problem with that. But then I've heard views that when it comes to expressing views, they'd like the administration to make some clarification. Let's say if it's based on objective facts and sincere criticisms are made against the government, or suggestions for improvement are made, and so on. Now, I represent trade association, so for chambers of commerce, trade or associations, or even enterprises, they may engage in advocacy work. For example, they want to propose legislative amendments or comment on certain issues, or they may even be against some of the proposals made by the government. Does it mean that that won't be affected? They wouldn't, and people wouldn't have breached or committed this offense? Maybe what if people report on the government department or strongly criticize the performance of government department, or they comment on the government's economic policies? Would that be against the law? So I'd like to hear the government's explanation. SJ, thank you, Mr. Lam. Well, this is one of the biggest concerns of the community on the bill. Now, let me categorically say this to you all. The offense of sedition certainly does not stop anyone from expressing views in opposition to the government's position, or even if they criticize government, then they could word their criticisms as strongly as they wish. There's not going to be a problem. I didn't say that. I'm not the one saying that. Actually, it's already in Section 9.2 of the Crimes Ordinance. That is a very important element in defining what is seditious intention. Because if it's just expressed views, it doesn't matter if it's very strong, there is no problem at all. Just last week, in the Tam Tak Chi case, in interpreting the same section, the court also gave a clear explanation, and that position is entirely subscribed to by the government. So people don't have to worry about criticizing the government. Actually, we need different voices, especially when it comes to policy making of the government. The different views will help the government to make better policies. But what are we targeting here? It's all about the intention, really. If the intention is you just want to do good for everybody, even if your view is not the same as the government, doesn't matter if it's very strong, we welcome it. But if what you're trying to say is to incite hatred, you want people to sabotage the government or the country, then of course it's a separate matter. So there's a need to make this distinction. Mr. Tony Chair. Thank you, Chairman. Now, this clause is relatively complex. It takes up 3 pages, over 700 words to explain what is seditious intention. I'd like to thank the SJ for again making a categorical clarification, because many in the community are concerned there may even be misunderstanding. As Mr. Jeffrey Lam just pointed out, well, if it's about inciting hatred, among the people of different regions of China, for example, then that's something we need to pay attention to. And that's why the SJ needs to explain that time and time again. Otherwise, someone may exploit that. That is, they will exploit people's misunderstanding or concerns. So I just want to I was going to ask a question about that, but since the SJ has already made his position clear, I have nothing to follow up on. Next, Mr. Holden Chow. Thank you, SJ, for making a categorical response. I would like to point out, too, now in the community, there's been much discussion about this, but then on different occasions, in particular at the Bills Committee meeting today, SJ, you have given a categorical response to put people's mind at ease. Now for Clause 22, Subclause 3 and 4, that actually includes what the SJ said in terms of a provision clearly. For example, for ABC, that is, you can make, you could give an opinion, you may criticize the government even though it's very strongly worded, it's fine as long as there is no seditious intention. You just want to criticize the government so the government improve their policy making. So it doesn't matter how strong or fierce your criticism is, it won't fall under the scope of seditious intention. Now, I heard you say this on different occasions, SJ, and then at the Bills Committee meeting today, you're again making that clearly. Perhaps for, in fact, in clauses, subclause 4A, B, C, there are clear provisions on that. I hope that will allay the concerns in the community. So I'm just making comment. Okay, Dr. Loai Kwok, thank you. Mr. Jeffrey Lam, actually, questions related to subclause 4, and other members expressed their views too. I share their views. Now, some people are genuinely concerned, but then there are others who intentionally try to distort the provision. Now, for subclause 4 A, B, C, D, that gives clear explanation about what is intention. That is, the intention is to give an opinion, or if it's an attempt to dispel hatred and so on, then certainly it is not seditious intention. So thank you for the clarifications, SJ. I think you need to step up publicity on that. Let me go to another point, Mr. Chairman. I may have mentioned it before. I noticed that the media is reporting much on what we've been discussing at this meeting, and then others give their views online. But there's one point that we've mentioned, but I think we need to reiterate that point, because for many in the business sector, now, about external forces, there's concern. They are worried that they may affect normal cooperation with external bodies or even recruitment of talents. But there's no need to be worried. In fact, yesterday and today, the SJ and other government officials have tried to clarify that. Now, international organization is a neutral term. Now, if you have any liaison or collaboration with other international organizations that is not breaking the law, it's only if you collude with the organization to engage in acts that endanger national security, then it's an offense. So that's why, as I said, we have to be careful. We need to make sure that no one with ulterior motive try to take provisions out of their context, and then they try to smear the bill. So yes, that's another comment. So perhaps you could give an overall response to all the comments later. Mr. Chen Xiu-Hong. Thank you, Mr. Chairman. Now, we're all very much concerned about this offense, seditious intention. Many in the committee in particular are very concerned. That's why the SJ tried to explain once again under what circumstances there would be reasonable defense for seditious intention. I have two questions, Mr. Chairman. First one. Clause 22, subclause 1b. Any act, word, or publication that has a seditious intention, if the act or word or publication is one or more of the intentions. Now, items were mentioned before, but here objects like sculptures are not included here, but objects could include anything, and objects could be means to could be something with seditious intention. And then for publication, there is a broad definition in Cap 1. What about for objects? Do they cover sculptures or not? SJ or Secretary Bill, Mr. Lai? Oh yes, I'll take the question, Mr. Chairman. About publication. Now in Cap 1, that is the Interpretation and General Clauses Ordinance, there is a definition. And that definition covers a wide scope. It could include objects for public display. So it's may fall under the definition of publication. Okay, so you've explained that. Second question. Clause 24, bracket 4, there are A, B, C, D. There's a defense, that is the 4 types of intention are not considered seditious. So we may have to refer to clause 24, which we'll come to later. That is whether there is a reasonable explanation or defense. Maybe A, B, C, D are part of that. Now, say many universities conduct research, or research institutes conduct research, and they have to collect both supporting and opposing views for analysis. That means they may even collect a document with seditious intention for analysis purpose. So would that be a reasonable defense? That is, I am in possession of such publications, items, or expression of views. It's just for analysis purposes, so I won't be caught by the law. So it's a question about a possible scenario. Deputy Secretary. We are talking about several different scenarios. Mr. Chen, examples that maybe is a research project, and then seditious materials are collected for research purpose. Now, may I like to refer you to clause 23(1), because the offense, that's the offense. Now, first there has to be a seditious intention. And then the act, say, of publishing words with seditious intention, then that's an offense. But then in your example, the person is not collecting or publishing the information with seditious intention, so it won't fall under clause 23(1). Now, what about clause 23(3)? A person without reasonable excuse possesses a publication. Now, the scenario I gave is that someone is an analyst. His job is to collect information for analysis. Would that be a reasonable excuse? In that scenario, that you described, the person collects the material not for seditious purpose. It's just collected in the course of normal research. But of course, it will be up to the court. But I would myself would consider that a reasonable excuse as to why the person is in possession of that publication. Well, if it's for academic purpose that the publication is collected, then of course there is no seditious intention. Ms. Carmen Ken. Are we still on clause 22, not clause 23? Yes, we're on clause 22. Clause 22. There's only mention of what intention is seditious and what intention is not. we haven't yet come to the offense or the elements of an offense. So the head of the rebuttal team and the SJ both said this is rather controversial, but I think if you could explain that more, we should be able to address the concerns as we point out the main points to members of the public. Because what is a seditious intention? So that's subclause 2, actually, of clause 22. And then subclause 3 says that if a person act only with any of the intentions specified in clause 4, then the act is not done with a seditious intention. So only with any intentions. The word only is important here. There must be no abuse of the clause. But I give the views only to improve the arrangement or the system or whatever. But then there could be other intentions, then it will be a problem. So in subclause 3, we must explain that it's only, the word only is key. That is, it's only, say, for improving the system or the views given through a lawful channel. That means we cannot use a lawful channel to achieve the purpose. Now, even if it's but if it's for inciting hatred among people in different regions of China, then it's not all right, of course. So the word only is important in clause 3a. I want to clarify if my understanding is correct. Deputy Secretary. Yes, it's exactly as Ms. Ken put it. Because if we allow them to include other intentions, then they may be trying to exploit subclause 4a to do something that's not allowed by the bill. That's why the word only is of utmost importance. Thank you. And then 22 bracket 2e. An intention to incite any person to do a violent act in the Hong Kong SAR. So this intention compared to what we discussed under clause 15d when we talk about insurrection. That is that person carries out the act himself with an intent to endanger the sovereignty, unity, or territorial integrity of China or the public safety of Hong Kong SAR, and that person engages in violent act. So in that case, the maximum penalty is life sentence. So that is the act of the person himself. But here, I think there's need to regulate that as well. That is, they don't carry the act themselves, but they incite someone else to do it, and that's a serious issue too. Some say there's no need for E because there are other provisions or other legislation that deal with that. So is my understanding correct here? So this means the person incites someone else to do the violent act. I think your question is clear. Now, Ms. Carmen D refers to clause 15D on insurrection. Now, that's a serious grave intention, that is to endanger the sovereignty, unity, or territorial integrity of Hong Kong or of China, or the public safety of the Hong Kong as a whole. So there's a far more serious offense. But here, the intention is to incite another person to do a violent act, and that may not endanger the public safety of the SAR as a whole. So it's just to incite others to carry out violent acts. So that's why the gravity is very different.
So at clause 23, we will be able to see what the offense and the consequences are. Chairman, I noticed that in subclause 2D, it says that an intention to cause hatred or enmity amongst different classes of residents of the Hong Kong SAR or amongst residents of different regions of China. That's one kind of an seditious intention. I remember that in 2019, there were some rioters who target mainland citizens. So do such kind of acts or activities fall within the definition of seditious intention? Also, we adopt this kind of racial discrimination ordinance. That is to prohibit acts against discrimination of people with different accents, race, or gender, and so on. The penalty for the offense under the racial discrimination ordinance is quite light. So would people make use of excuses to circumvent the law? Could that be someone, or could there be someone who would commit acts that endanger national security, and they make an excuse that they are just committing discrimination? As for Jay, please. Oh, sorry, Secretary for Security. In subclause D, there is an intention to cause hatred or enmity. The intention is not to discriminate, but to cause hatred or enmity. The nature of such kind of an intention is much more serious, so the penalty would be much more heavy than that falls under the racial discrimination ordinance. Let me supplement. As for whether the examples is included by the or regulated under the Opportunities Ordinance, well, the defendant cannot choose what offense that they would like to plead guilty to. As long as we have enough evidence that they have violated the national security law, then we will prosecute them. They don't have the rights to choose what offense they would like to plead guilty to, or that the police should charge them with. So would that constitute an excuse? The defendant could say that they were just trying to discriminate instead of causing hatred or enmity. Well, that would not constitute an excuse. The court will have to look at the criminal elements to see if there is enough evidence, if there is a defense. If there is not such a defense, then the court will not accept the excuse. Thank you. Mr. Lai Tong Kwok. I would like to ask about Clause 2, Subclause 2F. An intention to incite any other person to do an act that does not comply with the law of the Hong Kong SAR or that does not obey an order issued under the law of the Hong Kong SAR. Can I give you a scenario to see if it falls under such kind of definition? Since 2019, we've seen a lot of political activities that were illegal. There was a period of time when the court issued an injunction. And after the issuance of injunction, there were people who say that we don't have to follow the injunction. Under those circumstances, would those people have committed such kind of an offense? Or do they have such kind of intention as understood in the bill? Well, I think that would fall under the clause. Say if a person violates the face mask order, and they incite others to not to follow the order, then that would be a kind of incitement. Legal advisor, please. Thank you. We're looking at Clause 22, Subclause 4, and the operation of the clause. Let me cite an extreme example to illustrate the point. There could be a person who published an article, and the content of the article says that the judiciary of Hong Kong is corrupted. the judgment handed down by them are all wrong. And if the publisher is prosecuted, when the case goes to the court, if we read subclause 4, if the defendant gives an excuse that they are just pointing out hatred or enmity to improve the system, and if the defendant says that they think that the solution to the problem is that we have to have an election arrangement or system for judges, the court will have to make a judgment as to the intention is in line with those set out in subclause 4. There has to be a factual finding to see if the facts set out by the defendant is an objective fact. Only by then will we see or be able to tell if the intention falls under those set out in subclause 4. And then the judge will be able to make a judgment as to the intention or as to whether the intention is of seditious intent. When it comes to the operation of the bill, I hope that the example that I cite helped with the understanding. As for fact-finding, of course, we have to look at the context of the case. As for the case with Tam Tak-chi, a criticism of courts or the judgment handed down by the court is okay. We will be able to tell if there is any objective basis. If you're just criticizing the court without giving any solutions or suggestions, you're just saying that the court is corrupted, then people will be able to tell what your intention is. If you are only criticizing the wordings of the judgment, and if you have proposed some suggestions, then your criticism may not have a seditious intention. So we have to look at what grounds they have in proposing the criticism and the background of the defendant before we can be able to tell what the intention of the person is. Criticizing a judge is fine. We have to look at the context of the case. It could be that you are citing wrong information or false information. That would be fine as long as you don't have seditious intention. Well, the court will have to look at the objective or the purpose of the criticism before deciding on if the criticism is of seditious intent. Mr. Stanley Ng. I don't think that we will invoke Clause 22 very often because the prosecution threshold is quite high. We have to prove an intention. And the result of such an act would have to cause hatred and enmity among different classes of residents of the Hong Kong SAR. How do we know if hatred or enmity has been caused? Let me take the question. There were 2 cases that have been prosecuted. One with the Sheep Village. There is a speech therapist who published a storybook on Sheep Village. And there was another case that was completed yesterday with the case of Tam Tak-chi. The defendant was proven guilty of publishing books and articles with seditious intention. If there is no further question, would the Deputy Secretary please proceed? Clause 23. 23. Offenses in connection with seditious intention. Subclause 1. Any person who, with a seditious intention, does an act that has seditious intention or utters a word that has a seditious intention. B. Knowing that a publication has a seditious intention, prints, publishes, sells, offers for sale, distributes, displays, or reproduces the publication. Or C. Imports a publication that has a seditious intention, commits an offense and is liable on conviction on indictment to imprisonment for 7 years. 2. A person who colludes with an external force to do the following. A. With a seditious intention, do an act that has seditious intention or utter a word that has a seditious intention. B. Knowing that a publication has a seditious intention, print, publish, sell, offer for sale, distribute, display, or reproduce the publication. Or C. Import a publication that has seditious intention, commits an offense and is liable on conviction on indictment to imprisonment for 10 years. Subclause 3. A person who, without reasonable excuse, possesses a publication that has seditious intention, commits an offense, and is liable on conviction on indictment to imprisonment for 3 years. In this section, publish includes to communicate in any form, including speaking, writing, displaying notices, broadcasting, screening, and playing of tapes or other recorded materials, and B. To disseminate or make available. Questions. Mr. Jeffrey Lam. Chairman. About the offenses in connection with seditious intention, I would like to ask about subclause 4, publish. It says that to communicate in any form, including speaking, writing, displaying notices, broadcasting, screening, and playing of tapes or other recorded material. So my question is this. If someone on social media publish or upload messages with seditious intention, would the companies of these social media platforms violate the law? Well, if they collude, then that would definitely constitute a problem. What should the companies do in order not to be caught by the law? That's the problem with the contest. Government officials, please. Let me try to take the question. There is a platform for publishing, and the company or owner of the platform would not be the one to publish. In subclause 1, it says that a person who, with a seditious intention, publish publication that has seditious intention. If the company is only offering a platform for publishing such articles, then that would not constitute a problem. Mr. Leung, Chairman, let me supplement. If you look at the offense of publishing publications with seditious intention, we have to look at the intention here. You can refer to Clause 23, Subclause 1b. It says that the publication should has a seditious intention, and the defendant should know that a publication has seditious intention. For companies owning social media platforms or forums, they are not the ones to publish those articles or messages with seditious intention. The users would be the one to publish such messages. Unless the administrator of this platform know about such a kind of a publication that has seditious intention, otherwise they will not be caught by the law. Just now, Mr. Lam mentioned about colluding, then, well, if there is a collusion element, then of course the person should be prosecuted. There were cases where the administrator knows that the message published on that platform has seditious intention, but the administrator refused to take down those messages and posts. How should we deal with those cases? DOJ, please. We will have to look at the actual situation and the evidence. In this clause, it says knowing and seditious intention. If the person knows that a publication has seditious intention and prints or publish them, then they will be caught by the law. But we have to look at it on a case-by-case basis. Let me supplement. In the National Security Law, Article 43, well, the administrator will have to take down the post if we so order. Chairman, on offenses in connection with seditious intention, subclause 1, 2, 3. When the general members of the public read these offenses, they would be worried about subclause 1C and subclause 2C. For example, in subclause 1C, it says imparts a publication that has seditious intention. Impartation could include receiving emails when tourists come to Hong Kong and they bring a publication here. And sometimes perhaps they are not aware that a chapter in that publication has seditious intention. Then they would be inadvertently caught by the law. Subclause 2C is also worrisome for some members of the public. I think that we should read this together with clause 25. There is a defense. I think that is your intention, but it seems that, well, it's just that you're putting them in two different paragraphs. Should the person prove that they don't know the publication has seditious intention, is the burden of proof rests on them? How do you consider these objective factors? Thank you. Mr. Leung. Thank you, Chairman. We may have to refer to clause 25. Chairman, if you so permit, let me explain about clause 25 and how it operates. Well, why don't we consider it when we go to clause 25? I think that we have to read these two clauses together. Because people may think that we are focused on the terms of imprisonment and penalty. I think that we can alleviate the concern if we read 23 with 25 together. In clause 25, such kind of a phrasing is very common in the laws of Hong Kong. It says that there is evidential burden. This is different from the burden of proof. This evidential burden does not mean that the defendant have to prove that they don't know the publication is one with seditious intention. A lot of the case law shows that if the defendant can show that some evidence, that could be evidence deriving from the defendant or prosecution, and if such evidence induce a reasonable doubt, then the prosecution will have to prove beyond reasonable doubt that the defendant know that the publication is one with seditious intention. As for the operation of the clause, that complies with the principle of presumption of innocence. Thank you. Reverend Kuhn. Thank you, Chairman. About publication with seditious intention, for printing, publishing, and selling, people would know that these are forbidden. But as for possession, let me name an example. There was a newspaper that was very popular that is called Apple Daily. Some people want to keep this kind of a newspaper, they could keep a few copies at their home. Does this constitute possession of seditious or publication with seditious intention?
Who will take this question? The publication that was mentioned, the publication is in the course of a legal proceeding. So it'd be better for me to give general remarks. Yes, let's refer to general situations. When one imports publications with seditious intentions into Hong Kong, we have to see whether they constitute a defense for offense in accordance with Clause 25. And I have already explained that in my answer to Mr. Chan's question. Well, what about those matters before the passing of the bill? I understand the possession of publications with seditious intention are illegal, but what about those that are already available before the passage of the bill? I'd like the administration to clarify this matter. Thank you, Chairman. I understand what Reverend Peter Kuhn means. That is, some publications have already been published before this bill. Well, I don't think that's a matter. In the Criminal Procedure Ordinance, there are already offenses in relation to the possession of publications with seditious intention. After this legislation takes effect, how do we judge whether a publication has a seditious intention? We'll have to make a judgment after the publication of the publication. We need to be forward-looking. We do not take a retrospective look. So simply put, the date of the application does not matter. After the passage of the bill, when one possesses this publication with seditious intention, that person breaks the law. The date of the publication actually does not matter. To general citizens, they understand what distribution means, but when it comes to possession, well, I think the administration has already explained this point. But some citizens are still none the wiser. They don't understand what possession or defense for offense means when they keep the publication or when they have not yet taken out all the publications. What about these situations? When it comes to importing publications with seditious intentions, well, I think Reverend Peter Kuhn is still referring to subsection 3. And I think it boils down to whether there is any reasonable excuse. So, when one does not know that one still possesses that publication, that is a reasonable excuse. Chairman, I'd like to supplement. Thank you. SJ, this offense is not something new. In existing legislation, in sections 9 and 10 of the Crimes Ordinance, there are already existing provisions, so it is not something new. If it is a brand new legislation, I would understand the confusion, but it is not new. Next, Mr. Stanley Ng. Thank you, Chairman. In Clause 23, subsections 1A2, a person who with a seditious intention utters a word that has a seditious intention, and subsections 2A2, there is still, there are also the same provisions. Why is a word emphasized? What about pictures, videos? Why these are not covered? Why only words are covered? Can you explain this point? Who will take the question? Deputy Secretary. Thank you. This provision deals with publications. So, using the word Well, I mean, using words is an appropriate expression. So do you mean there are other provisions dealing with pictures? Ms. Sue? Publications are covered subsections 1b and 2b. That is when you publish the publication knowing that it is a publication with seditious intention, then this provision is applicable. Well, I mean, why this provision only covers words? Why does it not cover pictures, videos, or information of any other type? Subsections A2 focuses on words that are uttered. Under the Crimes Ordinance, there are also similar provisions. Words, or I mean utter, refers to words being spoken, being uttered. So different charges are invoked to target different behaviors. Next, Ms. Carmen Khan. Thank you, Chairman. I'd like to ask about offenses in connection with seditious intention. Just now, S.J. mentioned Criminal Procedure Ordinance, Sections 9 and 10. These two will be repealed. Under this bill, colluding with external forces, these are consolidated altogether to let the public know that there are seditious intentions, and when we cover it into the bill, what is the use of this? What purpose does it serve? Well, I can try to take this question. This bill is the Safeguarding National Security Bill, and we want to put together all legislation in relation to safeguarding national security. Just now, Ms. Carmen Khan mentioned the charge element of colluding with external force. The penalty is actually much heavier comparing with the previous or the original penalty as it concerns national security. That is why the penalty is much heavier. SJ? Well, that is actually in relation to other ordinances. That is in relation to the words, My Majesty, and so on. Yes, I do understand your explanation, and it responds to some questions or comments. Do we need to set out the core elements of the charge? For example, in Clause 23, which vice or mischief does it target? Well, I think there is no further doubt as to the fact that these provisions are not clear. The administration has already given a clear explanation. As long as the behavior has a seditious intention in accordance with subsection 1 of Clause 23. That is the 6 intentions just now mentioned. Next, Ms. Lai Tong Kwok. Thank you, Chairman. In relation to subsections 3 of Clause 23, a person who without reasonable excuse possesses a publication that has a seditious intention. First of all, I'd like to ask about without reasonable excuse. Does the defendant need to tender any evidence, or is it a charge element that the prosecution needs to prove? The next question is, how should I interpret possess? Does one need to know that a publication has seditious intention before one can be said to be in possession of a publication? When one possesses a publication, well, I mean, if one does not know that he or she possesses a publication, can it be said that he is in possession of a publication? First of all, on without reasonable excuse, in subsection 3, the burden of proof is on the prosecution. And the word possession is actually a common word in the laws of Hong Kong. Actually, possession covers the element of knowing. Actually, in Clause 25, there is a defense for offense, but that concerns importation. Any follow-up? No? Next, Mrs. Regina Ib. I'd like to ask about Clause 23, subsection 4, the word publish. By the looks of it, it focuses on words of any form, including speaking, writing, broadcasting, screening, and playing of tapes or other recorded material. What about balloons? Some words have already been held by the court to be seditious, such as Glory to Hong Kong, Revolution of the Times. If balloons with these words are in the air, is it also publication as long as some objects contain words? Does it also fall into the scope of publishing? Well, as set out in any form, communication in any form, when messages are carried by balloons in the air, that is definitely falling into this scope. What about sculptures? As members asked, there are no words, but the sculptures carry seditious intentions. Does it also fall into this scope? That is a sculpture without any words, but it contains strong seditious messages. It could be a seditious act. In 1A1 or 2A1, there is also such a word as act, and it will be covered under act. Any follow-up? No. Next, Mr. Stanley Ng in the second round, 3 minutes. Thank you, Chairman. I'd like to follow up on the point I mentioned. According to the administration, publications in words. But there are many different kinds of information, for example, songs, videos, do we have no way to pursue these acts? Why is it limited to words or publications? Well, these will be covered under Act. For example, the playing of songs and so on. In 1A1 and 2A1, the acts, songs can be covered under acts. In 1A2 or 2A2, they focus on words. In 1B and 2B, they focus on other publications. So these are all covered in 3 different aspects. Objects, articles were mentioned, so why don't you adopt a consistent approach? Mr. Leung? Thank you, Chairman. Just now I mentioned in Cap 1, the IGCO, there is a definition of the word publication. Well, that is any means to convey messages including pictures, films, or other devices. The other definition is anything irrespective of nature, contains any message, any image that can be seen, or can produce or repetitively produce any message. So basically, member mentioned videos, that is what we can see online. There is streaming videos and so on. These are all covered by the definition in accordance with the IGC OCAP 1. Any further question? If there is none, the Deputy Secretary can proceed with the introduction of Clause 24. Clause 24. Proof of intention to incite public disorder or to incite violence not necessary. Clause 1. In proceedings for an offense under Section 23, brackets 1a or brackets 2a, brackets a, it is not necessary to prove that the person does the act or utters the word with the intention to incite any other person to do an act causing public disorder, and b, unless the intention under Section 22, brackets 2e constitutes an element of the offense, it is not necessary to prove that the person does the act or utters the word with the intention to incite any other person to do a violent act. Subsection 2. In proceedings for an offense under Section 23, brackets 1, 2, or 3, a, it is not necessary to prove that the act, word, or publication as appropriate has the intention to cite any other person to do an act causing public disorder, and b, unless the intention under Section 22, brackets 2e constitutes an element of the offense, it is not necessary to prove that the act, word, or publication as appropriate has the intention to incite any other person to do a violent act. Ms. Carmen Khan. Thank you, Chairman. I'd like to hear from the administration. I'd like to know the reason for setting down this clause. I'd like to know why the proof of intention to incite public disorder or to incite violence is not necessary. Why is that not necessary? SJ? Thank you, Chairman. It's a legal issue that has been bugging us for a long time. Just now, in the case of Tam Tak Chi, the court made a judgment. Before the appeal case of Tam Tak Chi, in different jurisdictions, does the offense need to cover the seditious intention of public disorder or violence? Does it need to be covered? There are controversies. For example, in Canada, in the Privacy Council case, it seems to show that it is needed, it is necessary. But last week, in a Court of Appeal case, hearing the case of Tam Tak Chi, in sections 9 and 10 of the Crimes Ordinance, such an intention is not required to prove such. Despite so, we still cannot rule out the fact that, this is a judgment of the Court of Appeal, and one can take the case to the Court of Final Appeal, which will set the definitive tone. We need to codify that such proof is not necessary. The proof of intention to incite public disorder or to incite violence. Unless you refer to Clause 22, subsections 2e, as that's about an intention to incite any other person to do a violent act in the Hong Kong SAR. That would require proof to incite violence. And this is different from what members asked. Thank you, Chairman. I support this. Next, Dr. Kennedy Wong. Thank you, Chairman. In Clause 24, subsections 1b, it refers to Section 22, brackets 2e. Unless the intention under Section 22, brackets 2e constitutes an element of the offense, I'd like to ask Section 22, brackets 4e. So what about an offense that covers violence and non-violence? Some covering public disorder, whereas some not covering public disorder. Can the same ordinance be invoked? Does it mean that there will be a two-tier system of the penalty, as in some cases violence is involved, and in some cases violence is not involved? Thank you.
Mr. Leung, if I may assist. Now, under the current crimes ordinance, how do we prosecute in relation to the offense of seditious intention? We will have regard to the case. Now, if it's words or publication, and we can show more than one seditious intention, for example, inciting hatred against the government, at the same time inciting residents of Hong Kong not to abide by the law, then therefore in the charge, both limbs will be included in the details of the charge. Ms. Carmen Ken, anything else? Anything else, Dr. Kennedy Wong? Clause 23, bracket 1c. That is conviction on indictment to imprisonment 7 years is liable for 7 years. So does it mean that if there's violence, then there'll be heavier penalty? If it's, there's no violence involved or disruption of public order, then the sentence will be lighter. So it's just a maximum imprisonment. I think for this offense, there is just one maximum sentence. But for individual cases, well, whether violence is involved, of course, that will be a factor for the court, for the judge to consider the sentencing. But in any case, this is certainly one of the factors to be considered when a judge decides on the sentence. Yes, sentencing is done by judges. Ms. Carmen Ken, second round, 3 minutes. Thank you. Well, some may ask, when the DOJ prosecutes, there's no need to prove disruption of public order or the involvement of violence, then what needs to be written down that you need to prove? So you need to prove the seditious intention. That is the 6 types of intention in clause 26. And so, or in an earlier clause. So then there is no need to include the element of disruption of public order or violence. I think that has to be clear. And then for 4, who's to prove that? Is it just to for improving the system, or for just suggestions to make improvement? So if someone can prove that, then that shows that the intention is not seditious, but rather it's about improving the constitutional order. So is it for the person who advances the defense to prove that? So it's about evidential burden of evidential proof. Well, I think Ms. Ken is going back to the definition in Clause 22. Now, Clause 22, the essence about what constitutes seditious intention. That means we need to prove that someone has a certain intention. Definitely, the proof of burden is with the prosecution. Well, I asked this question because some expressed concern. How do I prove that is my only intention? So that means the public could be reassured. You don't need to prove that that's the only intention. Rather, it's for the prosecution to prove that. Thank you, Ms. Carmen Ken. I know you have good intentions asking that question. Mrs. Regina Ip. I think she's speaking for the first time, so 4 minutes. I'd just like to seek advice from the SJ and the Secretary for Security now. When we explain to someone what constitutes an offense, and we will tell them it's about mens rea. So that means there's no need to. So why is it worded that way? So how do I explain? For offences with seditious intention, there's no need to prove the intention of mens rea. How do I explain that to people? Well, I think we have to get this right. For clause 424 doesn't mean that we don't need to prove mens rea or intention, but rather we don't need to prove that the intention includes the intention to incite violence or incite disruption of public order. That means there's no need to, it's not that we don't need to prove the subjective intention. It's more about the scope of the subjective intention. It doesn't mean that we don't need to prove someone's seditious intention and that person could be convicted. Definitely that's not the case. Well, SJ referred to the recent Tam Tak Chi case ruling, and SJ said it's just a ruling by the Court of Appeal, and you don't rule out the possibility of that being overruled by the CFA. So if that's the case, do you have to amend clause 24? If that law becomes, if this bill becomes statute law, of course it's part of Hong Kong laws, and if it's something that happened before the legislative exercise, then of course it will be subject to the correct interpretation of the court. Let's say it commences on the 1st of July. So that means you don't have to prove that someone has seditious intention before the offense is proven. But then sometimes the court may strike down certain views. Are you worried about that? No, we're not worried at all. Well, the Court of Appeals ruling explains that clearly, and you see why there are adequate reasons on the part of the Court of Appeal, and explains why there's no need to prove the incitement of violence or incitement of disruption of public order. This is having regard to what happened in 2019, because many of those acts did not actually involve actual intention to incite violence, but then there are grave consequences, as we saw. We believe the current approach is definitely in line with the international standards on human rights, and definitely there's adequate protection of freedoms of speech, and we're not worried about that at all. Legal advisor. No, I like the administration to confirm. Now the SJ referred to the Tam Tak Chi case ruling. Now in clause 24, 1b, states here, if the intention is to incite any person to do a violent act in the Hong Kong South, there is no need to prove the intention to incite violence. So, and then that may not operate under the circumstance. So can the administration confirm that there is no need to prove the intention? There's an exception, actually, that is if the intention is about inciting any person to do a violent act in the SAR. And again, if we refer to the Court of Final Appeal ruling, paragraph 98 of the ruling, the court, it says here that the Court of Appeal looked at the process of drafting the crimes ordinance, and inciting violence is not a necessary element of the offense. This stated clearly in the court ruling. So perhaps can the administration confirm that? Yes, yes, I can confirm that understanding is correct. Next, Mr. Lai Tung Kwok. Now, the legal advisor referred to clause 22(2)(e). Definitely here we're talking about inciting violence. And then 24(1)(b) says that unless the intention under section 22(2)(e) constitutes an element of the offense. So the way it reads, it actually causes confusion, because 22(2)(e) should include in itself that there is need to prove that's the intention of inciting violence. So you need to prove that in this circumstance, but not in other circumstances. Well, my guess is that's the way it's supposed to mean. But then the way it reads here, it's not putting it in a direct way, but in a different way. It's trying to say it the other way. So is my understanding correct, Mr. Leung? Oh, Mr. Lai's understanding is basically right. Now, clause 22(2), seditious intention. There are different types from A to F. So for different cases, when the prosecution chooses which offense to charge, maybe a publication would not have all intentions from A to F. If say it's intention E only, and then the prosecution wants to charge the person in relation to publication with seditious intention, and if the intention is to incite violence, then this must be proven. For other intentions, there's no need to prove that. So that means if someone is charged under clause 24, and then if it involves clause 22(e), then there's need to prove that. For other types, there's no need to prove that. Is that right? Yes. Any other questions? If not, let's move on to clause 25. Defense for offense under section 23(1)(c) or 2c. 1. It is a defense for a person charged with an offense under section 23(1)(c) or 2c to establish that at the time of the alleged offense, the person did not know that the publication is a publication that has a seditious intention. 2. A person is taken to have established a matter that needs to be established for a defense under subsection 1 if A. There is sufficient evidence to raise an issue with respect to that matter, and B. The contrary is not proved by the prosecution beyond reasonable doubt. No questions? Clause 26, please. Clause 26, power to remove or obliterate publications that have seditious intention. 1. A law enforcement officer A may, subject to subsection 3, enter any premises or place, and B may stop and board any conveyance and may remove or obliterate any publication that has a seditious intention from there. 2. A law enforcement officer may take all or any of the following actions. A. To enter, by reasonable force if necessary, any premises or place that the officer is authorized under this section to enter. B. To remove by reasonable force any person or article obstructing the officer from exercising the power of removal or obliteration which the officer is authorized under this section to exercise. C. To detain any conveyance until all publications that have a seditious intention have been removed or obliterated from the conveyance. D. To remove any person by reasonable force if necessary from any conveyance while any publication that has a seditious intention is removed or obliterated. 3. If the publication that has a seditious intention is not visible from a public place, the powers conferred by subsection 1a may only be exercised. A. With the prior permission of the occupier of the premises or place, or B, under and in accordance with a warrant issued by a magistrate for such purpose. For in this section, there are two interpretations. One is law enforcement officer means a public officer or an officer of a law enforcement agency who is authorized by the Secretary for Security to perform the functions under this section, and a police officer or conveyance includes a vehicle, vessel, aircraft, and hovercraft. Mr. Kitson Yang. Now, there's mention of law enforcement officer, and it says here either a police officer or an officer authorized by the Secretary for Security to perform the functions under the section. Now, here we talk about removing publication with seditious intention. I understand many government departments have this functions. How come it's only limited to police officer or officer authorized by the Secretary for Security? How come it does not include, say, the Food and Environmental Hygiene Department? It has the power to remove such objects as well. Now, the spirit of the law is that if it's authorized by the Secretary for Security, then other persons could also remove the items. Why is it that we're not authorizing all law enforcement officers? Because here we talk about national security, and in particular we're talking about seditious intention. So it's something very solemn, and there's a need for stringent criteria. So that's why it's left to the Secretary for Security. So the Secretary for Security may authorize someone who has the power to judge what is in seditious intention. Mrs. Regina Ip, two questions. Wonder the government could confirm if my understanding is correct. One and two are different, right? One, a law enforcement officer needs to obtain a warrant, or there has to be consent from the occupier. But two, there's no need to do so. But then the difference is that we're talking about publications people can't see. The publications are not all over the territory. For two, it's less urgent. Now, law enforcement officer in Chinese is 警務人員 and English is police officer. Does it mean that you're ruling out the rank and file officers? So it has to be someone at an officer rank or above? Well, police officers refer to all ranks of police officers, so not just as junior police officers. They are junior. All police officers mean any police officers. So you mean police officers include police constables? Yes, all police personnel are police officers. So by extension, for an officer of a law enforcement agency, it doesn't matter if it's the Food and Environmental Hygiene or any other department, it could be anyone. Yes, as long as it's authorized by the Secretary for Security, then there's no restriction on ranks. You mean housing department? Well, if, say, under the housing ordinance, the housing department staff have certain enforcement powers, and if there's need in a particular case, then the Secretary of Security may authorize that person to enter the premises to perform certain functions. What if publications are posted on the MTR stations, then MTRCL staff may not remove the items at once? I don't think MTRC staff are law enforcement officers. Well, but of course, if it's if there is already enforcement power under the MTR bylaws, because there must be enforcement powers under relevant piece of legislation. So you mean it's not just MTR, perhaps for other corporations with bylaws, if they have enforcement powers, then they may be included as law enforcement officer. Mr. Leung will supplement, and then the Deputy Secretary will reply to your first part. Yes. The MTR has its own bylaw, so their staff have the power to remove these items. So already they have the powers to do so. there's no need to resort to this bill. On the first question, if I may explain, whether there's need to obtain a warrant. For one, it must be read together with free if we talk about the powers. Now, if something is not visible from a public place and it must meet some conditions, that is, the occupier must give consent, or warrant must be obtained from a magistrate. But if it's something that's visible from a public place, then there is no need to obtain a warrant. It can be removed. I think it makes sense. That is before the public has view of that, and you know about the publication, so it's not as urgent. You could just ask the occupiers to let you in, or ask for a warrant from the magistrate. But if something that the public could all see, like a balloon that flies across Hong Kong, of course, is more urgent. So there's no need to obtain a warrant. That's my understanding. Correct? Yes, absolutely.
係同意。
Agreed. Completely agreed. Mr. Tony Che. Thank you, Chairman. I would like to seek clarifications from the administration about subclause 4, conveyance, aircraft. Does that include unmanned drones? I'm not sure if I remember it correctly. There is regulations regulating drones. It seems that drones is not a kind of aircraft as set out in the regulations. You can actually form some kind of words with drones. Can the administration clarify? According to the Interpretation and General Clauses Ordinance, there is a definition of aircraft. That is, any device that can be born in air. According to this definition, unmanned devices and drones are covered. That is why we use this word of aircraft in this clause. Thank you. On this regulation on drones, is there some, well, regardless of the interpretation of the word drones set out in the regulation, that will not affect the definition here, correct? Well, because the regulations only cover the devices that fall under the regulation, that it will not affect the bill. Mr. Holden Chow. In clause 26, it seems that the focus is on physical publication. In Chinese, it's 航物. This clause covers physical publications, but as times change and advances, there are a lot of electronic creations that may have seditious intention. So will the law enforcement officer be able to enter premises to remove or obliterate electronic publications? I'm not sure if this clause will apply. Let me try to take the question. This clause 26 regulates physical publication. For online publication, we can invoke Section 43 of the Hong Kong SNL. Okay, so as long as we know which law to invoke. Ms. Carmen Khan, I have some similar questions. Under Division 4, there is the use of this word publication. I think that, are you referring to paper-based publications? Because in Clause 23, Subclause 4, the definition of publish is broad. It includes speaking, writing, displaying notices, broadcasting, screening, and playing of tapes or other recorded material. will you redefine the word publication to include electronic publication? Thank you, Chairman and Ms. Carmen Khan. About the definition of publication, there is not a differentiation between online and offline publication. About the publication of publishing of publications of with seditious intention, we do not differentiate between online and offline. The only time when we make a differentiation is with Clause 26. We use Clause 26 to empower law enforcement officers to remove or obliterate publications. As for online publications, we can invoke Section 43 NSL Section 4 of the implementation rules to reduce or to remove or obliterate publication. That's very useful. Thank you. Mr. Chan Xiu-Hong. I would like to clarify a point. In subclause 3, it says that if the publication that has a seditious intention is not visible from a public place, the powers conferred by the subsection 1A may only be exercised with the prior permission of the occupier and with the issuance of warrant. As for conveyance, it says that the law enforcement officer can enter any conveyance or board any conveyance. As for subclause 3, it says that the law enforcement officer can detain any conveyance. But then the detention of conveyance does not apply if the publication is not visible from a public space. If you need to board a vessel to remove or obliterate a publication that has seditious intention, would the law enforcement officer be able to do so? In subclause 3, it says that the powers conferred by subsection 1A may be exercised. As for subsection 1A, we are talking about entering premises. So Mr. Chen is correct. The requirements of obtaining a warrant only apply to entrance of premises. It's impossible for you to obtain warrant to board any conveyance because they move. That is the reason for that. So the law enforcement officer will have to board those conveyance immediately to remove or obliterate the publications that have seditious intention. Clause 27. Extraterritorial effect of divisions 2, 3, and 4. Subclause 1. If any Hong Kong SAR resident who is a Chinese citizen, body corporate that is incorporated, formed, or registered in the Hong Kong SAR, or body of persons, whether corporate or unincorporated, that has a place of business in the Hong Kong SAR, does any act outside the Hong Kong SAR, and the act would have constituted an offense under Section 17(1) had it been done in the Hong Kong SAR, the resident or the body commits an offense. If any Hong Kong SAR resident, body corporate that is incorporated, formed, or registered in the Hong Kong SAR, or body of persons, whether corporate or unincorporated, that has a place of business in the Hong Kong SAR, does any act outside the Hong Kong SAR, and the act would have constituted an offense under a provision specified in subsection 3 had it been done in the Hong Kong SAR, the resident or body commits the offense. Subclause 3. The provision specified for the purpose of subsection 2 is A. Section 18(1), 2, 3, or 4, B. Section 19(1) or 2, C. Section 21 or 2, or D. Section 23(1) or 2. I will not repeat the definition of Hong Kong SAR resident. Yes? Ms. Carmen Khan. Chairman, I would like the administration to clarify their consideration of including this extraterritorial effect under this offense. Because during the consultation period, we mentioned that we should make use of a proportionate principle, the DOJ would have to look at the elements of the offense before they decide on imposing extraterritorial effect on any offense. As for Clause 27, bracket 1, it sets any Hong Kong SAR resident who is a Chinese citizen. If we look at subclause 1B, for clause 17, we're talking about incitement of members of Chinese armed force to mutiny. This is a very serious offense that carry life imprisonment term. Now we only limit the extraterritorial effect to Hong Kong SAR resident who is a Chinese citizen. It seems that we are adopting this personality principle. If we incite members of the Chinese armed force, that could include military or soldiers of the People's Republic of China, then only if that's the case will we apply extraterritorial effect. Should we not adopt protection principle? What is your consideration? Thank you. Thank you, Chairman. About this offense on incitement of members of Chinese armed force to mutiny, as mentioned, the maximum penalty is life imprisonment, which this is a very serious offense. So we have drawn the drawn reference from the extraterritorial effect of treason. And we think that it should apply to the legal entity established in the Hong Kong SAR. So that is how we come up with a decision to include this element in the offense. Chairman, in Roman number 3, it says body of persons, whether corporate or unincorporated, that has a place of business in the Hong Kong SAR. We include them in this clause, whether or not they are in Hong Kong or outside Hong Kong. As for incitement of members of the Chinese army to mutiny, the defendant may not be in Hong Kong. We can charge them as long as, for this clause 27, we can charge the defendant as long as they have a place of business in the Hong Kong SAR. Is that correct? Well, because treason is a very special offense, the offense itself does not apply to the body corporate registered in Hong Kong. That offense only applied to a natural person. Because in this clause, clause 27 or 17, we include body corporate registered in Hong Kong and legal entity. So that is why there are 3 limbs to this part. Now we move on to the next part. That is part 9, division 9. That is clause 131. We already scrutinized that when we looked at the offense of treason, so we will not be reading that out. Well, we have already discussed that. So that's what I said. We already scrutinized that when we discussed treason. So let's move on. Part 4, offenses in connection with state secrets and espionage, Division 1. Deputy Secretary, 28, interpretation. In this division, public officer means a person holding an office of emolument under the government, whether such office be permanent or temporary, be any of the following persons if the person is not a person mentioned in paragraph A. 1. A principal officer of the government appointed in accordance with the Basic Law, the monetary authority appointed under Section 5A of the Exchange Fund Ordinance, the chairman of the Public Service Commission, staff members of the ICAC, the Ombudsman, and the person appointed under the Ombudsman Ordinance, the Privacy Commissioner for personal data, or person employed by under the Personal Data Ordinance, the chairman or a member of the Equal Opportunities Commission, or a person employed or engaged by the Commission under the Sex Discrimination Ordinance, and a judicial officer or staff of the judiciary. Now, Executive Council members, Legislative Council members, District Council members, and a member of the Election Committee. Now, definition of region. It means a region not being a country outside the Hong Kong SAR. Now, we move on to disclosure. In relation to a document or other article includes parting with possession of the document or article and disclosing the information contained in the document or article. Now, specified disclosure. We will discuss that in Section 29. Government contractor means a person who is not a public officer but who provides or is employed in the provision of goods or services for the purpose of the government or under agreement or arrangement that is certified by the chief executive as being an agreement or arrangement to which the authority of a region or place, the government of a foreign country, including institution under the government, or an international organization that is a party or that is subordinate to or made for the purpose of implementing any such agreement or arrangement. Now we move on to state secret. It means one of the following secrets, the disclosure without lawful authority of which would likely endanger national security. There are 7 categories of state secret. A secret concerning major policy decision on affairs of China or the Hong Kong SAR. B, a secret concerning the construction of a national defense of China or concerning a Chinese armed force. C, a secret concerning diplomatic or foreign affair activities of China. A secret concerning external affairs of the Hong Kong SAR, or a secret that China or the Hong Kong SAR is under an external obligation to preserve secrecy. D, a secret concerning the economic or social development of China or the Hong Kong SAR. E, a secret concerning the technological development or scientific technology of China or the Hong Kong SAR. F, a secret concerning activities for safeguarding national security or the security of the Hong Kong SAR or for the investigation of offenses. G, a secret concerning the relationship between the central authorities and the Hong Kong SAR, including information on affairs relating to the Hong Kong SAR for which the central authorities are responsible under the Basic Law. Lastly, information, except in Section 31 or 32, includes information stored by electronic means and message or intelligence that is not stored on any medium. About the definition of public officer, a lot of members have asked questions about that in Part 3, Division 3, when we discuss incitement to mutant or disaffection. Please note. Now it's time for questions. Mr. Holden Chow. Thank you, Chairman. About the definition of state secret, there are foreign governments who criticize that the definition of state secret is not clear. I've done some research. There are 7 categories to the state secret. If we compare this to the UK, they passed the National Security Act last year. Their definition of state secret is, well, they call it another name, that is protected information. They define it as for the purpose of protecting the safety or interest of the United Kingdom. That's all. They only say that as long as the information relates to the safety of interests of the UK, that would constitute a protected information or state secret. If we compare our definition with that of theirs, their definition is definitely broader. when they're trying to smear us, they should take a good look at themselves. The definition of state secret in our laws is much more clearer. Well, let me raise a point. In the offense in relation to theft of state secret under the National Security Act 2023, the maximum penalty is life imprisonment. As for theft of state secret that we will come to later on, the maximum penalty is 10 years of imprisonment. Only those specified person will be subject to a 10 years imprisonment term. For regular members of the citizen, they will only be sentenced to 5 years. It seems that our penalty is much lighter than that imposed by the UK. That's my comment. Thank you.
意見表達，睇下有冇官員回應。局長。
Any response from the administration? Mr. Holden Chow's is very correct in his observation. I might invite Mr. Holden Chow to join the rebuttal team. Ms. Carmen Khan. Thank you, Chairman. Just now, the definition of public officer was mentioned, and we need to review it. Just now, we mentioned the risk of incitement to disaffection if the airport authority, the SFC, the Hong Kong MA chairman, they may have a high risk of being incited to disaffection. Given their status, they may know the secrets in relation to the development of the country. So I hope that the administration can review the definition. Just now it was mentioned that the definitions are consistent. And riding on Mr. Holden Chow's point, I'd like the administration to tell us the experience in relation to overseas countries. That is the definition of state secrets. How is our definition different from theirs? We have A to G, but for some foreign governments, they do have a broader definition. As long as they touch upon national security, national interest, they are also protected information. So can the administration clarify this point? Regarding the first point, it is a view from the member. Regarding the second question, Deputy Secretary, please. Thank you, Chairman. Thank you, Member. Member's observation about the UK is very correct. According to the National Security Bill 2023, the word protect information, is it any information or document or article in relation to the development interests of the UK? If leaking the information will affect the commercial, economic, financial interest and is very likely to endanger the national safety of the UK or its prosperity, this will be called secrets. We have listed A to G, but then the definition used by the UK is quite sweeping. It's quite general. It just touches upon commercial, economic, and so on. Say, for example, Canada, Section 16 of the Information Security Law, that is about protected information. That is the Security of Information Act of Canada. It provides the scope of information. That is, it defines what protected information means. So as Ms. Carmen Khan said, it's quite vague, general interpretation of the offense, which is different from ours. Ours is much more detailed. Well, Ms. Carmen can actually join the rebuttal team as well. Next, Mr. Stanley Ng. Just now, Mr. Martin Liao also referred to the definition of public officers, which was copied from previous sections or clauses. But now, when we touch upon offenses in relation to state secrets, those handling these secrets from educational institutions like universities, they may also handle secrets. So why aren't they also covered? Can you explain? Our country also passed a law protecting state secrets. It provides for the definition, level, and protection of protected information. It provides a regulation and a mechanism for these protected information. It is very clear. I'd like to know whether the administration has drawn reference from this law of our country. That is the law of the People's Republic of China on guarding state secrets. Well, we have 3 levels of state secrets. Can you tell us more about the different levels of state secrets? Well, giving up on some articles also contributes to disclosure. If someone claims that he or she loses some items, does it also constitute disclosure? Security Chief, I can take the question. Regarding the classification of state secrets, we have a security principle. That is, there are different levels of information. That is top secret, secret, confidential. To a certain degree, you can say that it shows whether a document is confidential and whether an ordinary person has the authority to disclose the information. As long as one does not have the authority to disclose information, whether the information is secret or top secret, still one does not have the authority to disclose such information. We do have an internal classification of secrets mechanism that is for administrative purposes. Irrespective of the classification according to our internal mechanism, as long as one does not have the authority to disclose information, it already fulfills one of the criteria as set out. That is, one does not have the authority to disclose information. That is why we did not equate the classification mechanism with that of state secrets. As long as one does not have the authority to disclose, that person should not disclose the relevant information anyway. Deputy Secretary. Basically, the Secretary already explained the concept. Our practice differs from that in the mainland. Our protection mechanism is based on our own security principle. While the law in the mainland may be of reference value to us, but it may not be completely suitable if we simply model our mechanism on theirs completely. Mr. Tommy Zhang. Please go on, Mr. Tommy Zhang. According to the definition of state secrets, that is, it touches upon commercial, economic, technology. Without a reasonable authority, disclosing such information will endanger national security. That will constitute state secrets. There is no definition, however. When I glance at other provisions, I did not spot any definition either. In clause 33 bracket 3, for the purpose of this division, a disclosure by a person who is neither a public officer nor a government contractor is made with lawful authority. And I'd like to know, what about non-government contractor, research institution? I'd like to know the authorization mechanism according to the bill. If some people do not follow the mechanism set out by the organization and possess and disclose information that may jeopardize the development interest of China or the interest in relation to technology of Hong Kong SAR, the state secrets may endanger national security. Could the relevant person be exempt from prosecution, or can that person use this defense? I'll try to take this question. Secretary for Security. I also understand that science and research are of interest to people in the community. This is one's own research outcome, but they may also constitute state secrets. Our stance is that if the research is conducted by a person completely and there are no restrictions, they would not constitute state secrets. What does it mean? It means that if something is invented by someone, it would not constitute state secret. But for example, if something is invented in conjunction with the government, or the government does play a part in the course of the research, for example, the government gives funding to the research of the product so that there is a collaboration mechanism. In such cases, when there are restrictions, this may constitute a state secret. If something has nothing at all to do with the government, it may not constitute, or it will not constitute state secrets. Deputy Secretary, if there are science and research products that are so important that they fall into the scope of state secrets, well, I think most likely these projects may have the collaboration of the government. The government probably has a role to play in these projects. So that will have already been dealt with in the definition of state secrets. Well, I'd like to ask about legal or lawful authority. Ms. Siu? On lawful authority, we need to refer to clause 36. Can I refer to clause 36? Yes. Clause 36 is on authorized disclosure for section 1. For the purposes of this division, a disclosure by a public officer is made with lawful authority if and only if it is made in accordance with the officer's official duty. The second one is about government contractor. For the purpose of the functions by virtue of which the contractor is a government contractor and without contravening an official restriction that would constitute lawful disclosure. And we can refer to subsection 3, a disclosure by a person who is neither a public officer nor a government contractor is made with lawful authority if and only if it is made in accordance with an official authorization. And we need to refer to subsection 6 in relation to official authorization. It means an authorization duly given by a public officer or government contractor. Does it answer Mr. Tommy Zhang's question? Yes. Next, Mr. Jeffrey Lam. On the definition of state secrets from A to G, it tells us a lot about state secrets. It's very clear. Some have to do with diplomatic affairs. Some have to do with the armed forces of China. But in D, it's about a secret concerning the economic or social development of China or the Hong Kong SAR. It may concern some policies. What would constitute a secret? Economic policies, measures can cover a wide spectrum of things. Can you clarify what would constitute state secrets? Can you tell us a little bit more? You understand that the business sector has a lot of economic activities. We do have views on the development of Hong Kong. Can you tell us more about it? What would constitute a state secret? Secretary, I'll try to answer this question. Thank you. On state secrets, for something to constitute a state secret, there are 3 elements. First of all, it is a secret concerning the economic or social development of China or the Hong Kong SAR. This is one of the factors. The other 2 factors is that whether there is lawful authority in its disclosure and whether it is highly likely to endanger national security. These are the 2 factors I mentioned. And coupled with the factor about the economic and social development of China or the Hong Kong SAR, when all 3 factors are met, then something will constitute a state secret. What about the offense? For example, disclosing state secrets, there are 2 provisions. One has to do with intention, and the other has to do with the intention to endanger national security. So that is to say, when you disclose something that is considered state secret, you also need to have the intention to endanger national security. That is how one would breach this offense. These are the full charge elements. So on the definition of state secrets, something that is in relation to the economic or social development of China or the Hong Kong SAR alone would not constitute a state secret. We also need to factor in lawful authority and disclosure before we can consider something as a state secret. Let's pause right here for this meeting, and we'll resume at 4:40 p.m. Meeting adjourned.